being a lawyer, do you think he got a fair deal, in his sentencing?
Yes. Without hesitation, I would say that he got a fair deal.
Okay.
But even at that deal could be fairer.
Oh, I see. Okay.
He chose to plead guilty, thereby saving precious prosecutorial resources and time. So the thing was not out. And so he was convicted of the offense, and the sentencing was reserved. Now, the judicial policy and criminal law justice administration policy is to decongest the prison. And you recall that recently the state even went as far as paying the fines of a number of prisoners just to decongest the prison. Prisoners that fell in the category of committing simple offenses, minor offenses, but who have been jailed, given option of fines, but who could not pay. So the state, volunteered to pay, although it was a state private sector participation, so we were told by the Ministry of Internal Affairs. And on that occasion, the number of them were released. So the policy of the state is to ensure that the prisons are decongested as much as possible, and those who have not committed violent and very terrible offenses are given non-custodial punishment. That's why the Administration of Criminal Justice Act that was made in 2015, that has become very popular, has a lot of creative and innovative provisions, including probation, suspended sentence, community service sentence, etc., etc. Meaning that since that is the procedural law that is applied in criminal justice administration at the federal level, including the Federal High Court, and that law is also the law that is used by the EFCC, the court will have resorted to that. So, as it were, as egregious as that conduct of abusing the naira was, to reward the criminal defendant who had been convicted of the offense, who didn't waste the time of the court, who didn't waste precious adjudicatory time, because if he had said he wasn't guilty and the trial had been drawn out, all sorts of witnesses would have been summoned to court. The musician, perhaps, who was singing, where he was praying money, would have been summoned to court. All the Nollywood people would have been summoned to court, and that would have been drawn out. So, courts have a way of rewarding that, quote and unquote, good courtroom behavior, good defense behavior by the criminal defender, and the court will have done this. But all the same, the judge had a discretion, and the judge must have exercised his discretion judicially and judiciously, as lawyers will say. The judge felt that that verdict be returned without an option of fine to serve a lesson. 50,000, somebody that was praying perhaps 1 million, 2 million naira.
Exactly.
50,000, you will just go to his bank and drop it, and the optics will not be fine. I know that the mantra is that let justice be done even though the heavens fall. The judge is not supposed to pander to the feelings of public, but all the same, if you had a situation whereby, just like a former governor of a South state who engaged in plea bargaining with the EFCC, and he pleaded, when he pleaded and he was convicted, he just went to the back of Mercedes Benz car, on that occasion, many years ago. People have forgot this, and just brought out the money, 1 point something million, and then gave it out and went home, and people are wondering what had happened. Whereas the charge was that billions of naira, had been stolen and so on and so forth. You also recall a judge, Justice Talba, in Abuja, who also, gave a ridiculous sentence because he said that he had a sentencing discretion, and the matter went on appeal, and that decision was reversed. So the judge acted in accordance with the law, and so
we can comfortably say, can he appeal the sentence though?
Criminal proceedings, if a criminal defendant, pleaded guilty and was accordingly convicted of the offense and sentenced, it's like a consent, judgment. And in any case, even if it could not be likely to read, what is it going to demonstrate on appeal? What's going to be the grounds of his appeal? What will he be seeking? That the judge didn't convict him properly. Hey, the section provides 50,000 naira as a fine or 6 months imprisonment. The warden didn't leave a margin. He didn't leave an elasticity. In other words, you didn't have some provisions are worded this way: a maximum of 6 months imprisonment. Meaning that you can send the person to 1 day, 2 days, and also you have a statutory minimum and a statutory maximum. This one didn't say so. It provides 6 months imprisonment. So the judge couldn't dance much, even if he wanted to reward his good conduct that I've alluded to earlier.
Okay, it's nice.
So the possibility of appeal is just
for him to have said he was guilty. Did he really have an option, if what I would call viable option? Could he have stressed it to say I wasn't guilty, that he wasn't guilty? In which case the trial could stretch on for 6 months to 1 year, and so on and so forth, and all kinds of things can happen. Do you think he was given certain assurances? That's why he must have said that he was guilty. It's possible that the 50,000 was in his pocket.
Let me say this. We have to avoid speculation and proceed on the basis of what we know and the information that is available out there, and analyze it. The first thing I want to say is that, look, a criminal defendant has a right to plead guilty, not guilty. He can even remain silent or plead to the charge and all that. So we have a number of pleas. So he had an option to plead not guilty and to take his chances by mounting a strong defense. The presumption of innocence until proven guilty was still in his favor, and this is a constitutional right.
Yes.
The second issue is that to those who might think that there was a plea bargaining deal or a plea bargain deal, now in the court proceedings, no plea arrangement was mentioned.
Okay.
If a criminal defendant and a prosecution agency like the FCC wanted to engage in a plea bargain arrangement, it's not a hush-hush matter. It will be written. There will be a plea agreement that will be filed in court.
Okay.
And the court will have to reference it and adopt it in sentencing. Once the court asked the party if they truly were in agreement and that the criminal defendant in particular agreed with the plea agreement. That's what the provisions say in the Administration of Criminal Justice Act and the Administration of Criminal Justice Law in Lagos State. So it's not a hidden thing. So the fact that there was no mention of a plea arrangement in courts should presuppose, or we should presume, that there was no plea deal. Now, without a formal plea deal, could there have been an encouragement?
Yes.
By the prosecution, informally.
Yes.
But very potent, in its assurances. Could there have been an arrangement that, look, there is a tape and all that, so plead guilty? For example, people noted, and I noted it too, that whereas Idris Okuneye had been charged to court on a 6-count charge, some containing, the last two, I believe, were money laundering charges.
Yes.
the money laundering charges were dropped in court.
Yes.
And so the EFCC focused only on this abuse of the naira note. So was that the carrot that was thrown to him that, look, we'll charge you for money laundering, and because we could sustain that charge against you. Again, prosecutors also do this, and there are prosecutorial directives and guidelines, that frown at that practice, the practice of overcharging, so as to put pressure on criminal defendant to plead guilty, in a plea arrangement. So we do not know whether this was the scenario because we had no information to that effect. The EFCC will not say that there was a plea bargain arrangement, formally or informally, or that there was a pressure on him to plead guilty so that the money laundering charges could be dropped. Okuneye himself will not say. At least his publicist or lawyer has not to say that that was